Okay, so our case is the massacre in Bosnia and Herzegovina, and the team is Ro'i, Omri, Doreen, and Ido. First, we're going to see a short video about the subject. So this was the short video, and now we are going to look up at the case caption. In this instance, the appellant is the Republic of Bosnia and Herzegovina, and the appellee is Yugoslavia, which is Serbia and Montenegro, and it took place on the ICJ. Okay, so this is the material fact. Bosnia and Herzegovina claims that since the breakup of Yugoslavia on March 1992, Serbia, Croatia, and Montenegro has committed act of genocide against the people and the state of Bosnia. through its military forces. This includes killing, raping, causing seriously bodily and mental harm, deliberately inflicting conditions of life calculated to destroy the Bosnian groups, and imposing measures to prevent birth. The accusation include a systematic campaign of ethnic cleansing, which was aimed at the Bosnians Muslim, the Bosniak. They were murder, torture, rape, kidnapping, and there were destruction of villages and towns, bombing of civilians, siege of residential areas, starvation, and disruption of humanitarian aid.
Main legal questions. Jurisdiction. Did the ICJ have jurisdiction considering FRY or Serbia and Montenegro's UN and ICJ status? 1996 judgment. Interpreting the Genocide Convention. Does it obligate states not to commit genocide directly? What is the scope of the duty to prevent genocide? Can states be responsible without individual convention? Serbia's responsibility. Was Serbia complicit in genocide? Procedural history. On March 20, 1993, Bosnia and Herzegovina filed an application against the Federal Republic of Yugoslavia at the International Court of Justice, ICJ, alleging violation of Genocide Convention. The ICJ was the sole court involved in this case. The case lasts for a total of 14 years, with delays occurring due to the respondent conduct. Following Montenegro's independence in 2006, Serbia became the sole respondent. Through the proceeding, the ICJ issued several orders and judgments. In 1993, the court issued orders, provisional measures. Later, in 1996, the court delivered a judgment on preliminary objection affirming its jurisdiction. Finally, in 2007, the ICJ issued its final judgment on the merits of the case. Bosnia and Herzegovina act as the petitioner, while the FRY, which later became known as Serbia and Montenegro, and finally as Serbia alone, served as the respondent.
The 2007 judgment in the case of Bosnia and Herzegovina against Serbia, the International Court of Justice, ruled by majority opinion that the tribunal had jurisdiction over the claim under Article 9 of the conviction of the crime of the genocide. Serbia did not commit, did not conspire, and did not need to commit the crime of genocide for obligation under conviction. The court decision. Now I read the majority. The tribunal found that Serbia violated its obligation to comply with the interim orders issued by the tribunal in 1993, to the extent that it did not take all the measures it is disposed to prevent the genocide in Srebrenica in July 1995. The tribunal determined that its finding regarding the violation by Serbia constitutes sufficient relief, and that this is not a case where the payment of the damage would be appropriate. Now I read the dissenting opinion. Vice President Al-Hassana thought that the majority judge reached wrong conclusion regarding the Serbian responsibility for the genocide in Bosnia, due to his of legal misuse and the exception that it did not match the fact of the case. In his opinion, if the court had examined the evidence properly, it would likely have found Serbia responsible for the genocide as a principal accomplice or accessory. Joint minority opinion of Judge Geneva, Shea, and Koruma, they reverse the application of the principle of finality of discussion, res judicia, to the 1996 judgment to determine by way of necessarily implied that the issue of jurisdiction, ration, a person has already been decided. In their view, the ruling ignored substantial question before the court regarding Serbia, Montenegro's membership in the United Nations and its being a party to the genocide conviction.
Over the ramification of the case, this was the first time a state was sued before the International Court of Justice for violating the Genocide Convention. The judgment clarified the scope of state obligations under the convention and the standard for attributing responsibility. It was delivered in 2007 regarding events from 1992 to 1995, demonstrating the long-term importance of establishing legal responsibility even years after a conflict. The case remains highly relevant today as a precedent on state responsibility related to genocide. So the relevance of the case to our times and days. The massacre in Bosnia and Herzegovina is relevant to our times, as even today, various types of genocide are taking place in our world. For example, in Rwanda, and on activities against humanity that carried out by the Russians against Ukrainian citizens. Security has not yet been created in a world where citizens all over the globe can live without fear. Moreover, the horrible massacre that happened on the 7th of October is a gross and extensive violation of human rights, which prove the fact that the world has not yet applied the lessons from the massacre in Bosnia. So what did we learn from the case? This complex case illustrated key legal issues on jurisdiction, state responsibility, and interpretation of the Genocide Convention. It highlighted the importance of properly establishing the requisite specific intent for genocide and the high threshold for attributing genocidal acts to a state. At the same time, it affirmed state proactive duty to prevent genocide in areas under their influence. The various dissents also showed the challenges in reaching consensus on these weighty issues. Overall, it exemplified the vital role of the International Court of Justice in advancing accountability and legal clarity, even on the most serious international crimes.